Hello friends. The topic for today's lecture are two topics. First is that analysis of provisions of Limitation Act with respect to Insolvency and Bankruptcy Code 2016. And another topic is analysis of withdrawal of CIRP proceedings pursuant to settlement under Section 12A of the Insolvency and Bankruptcy Code 2016. For the sessions, along with me, we have our expert, Mr. C. Ramachandra Rao. Hello. He is a General Manager with Insolvency and Bankruptcy Board of India. Hello. Moving to the first topic, which is the analysis of provisions of Limitation Act with respect to Insolvency and Bankruptcy Code. Let's first understand the basics of what is Insolvency and Bankruptcy Code. Insolvency and Bankruptcy Code is one of the deepest economic reforms along with GST. It comes into picture when one is not able to pay its debt or defaults in payment of its debt. The code provides for resolution or liquidation for corporate entities and also provides for insolvency resolution or bankruptcy for individuals. All these processes under the code are actually time bound, and specifically there is a time period provided for each of these processes. Now, to understand better, let's look at the preamble of the code. It says, it is an act to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals in a time-bound manner. And the objectives which are to be achieved through this process are that it ends up maximizing the value of assets for such stakeholders. It promotes entrepreneurship. It improves the availability of credit in the system, and also it balances the interests of all stakeholders. Now, when we talk of the broad features of the code, the broad features are that it is a comprehensive legislation, and it removes the multiplicity of laws. So the act has ended up repealing the Presidency Towns Insolvency Act, the Provincial Insolvency Act, and also the Sick Industrial Companies Act. It provides for time-bound resolution. For example, the process of resolution, which is a corporate insolvency resolution process for a company, it is provided that the process has to be completed in 180 days. And a single time extension can be taken of that of 90 days. The Act provides for both corporate and individual insolvency resolution. It also provides that the adjudication is to be done by tribunals like that of NCLT, NCLATs, and for individual insolvency, it is DRTs and DRATs. The processes under the code are professionally managed. For these, we have insolvency professionals who are appointed by the court, and they are the ones who supervise the whole process. Then we have avoidance transactions under the code, which are, if there are any transactions which fall in the category of preferential, undervalued, fraudulent, or extortionate credit transaction in a particular look-back period which is provided in the code, then those kind of transactions can be avoided by the adjudicating authorities. Also, in the liquidation, in the waterfall mechanism, the government has taken a seat back in the code, and priority has been given to interests of workmen and employees. Also, for regulating the process as well as the profession of insolvency professionals, we have a regulatory body, which is the Insolvency and Bankruptcy Board of India, which has the power to inspect, prosecute, and issue disciplinary orders against these insolvency professionals. On the other aspect, when we look at the Limitation Act is based on a Latin maxim, which is vigilantis non dormantibus jura subvenient. It means that law helps only those who are vigilant and not those who sleep over their rights. It prescribes a particular time limit for each kind of a suit, within which time limit one has to approach the court of law. If one does not approach the court of law, then the suit becomes time barred and will not be accepted by the court and will be struck down by the law of limitation. Specifically speaking, Section 2J of the Limitation Act defines period of limitation to mean the period of limitation as prescribed for any suit, appeal, or application in the schedule ascribed to the Limitation Act. In the schedule, we have 137 articles prescribing various time periods for different kinds of suits and also for appeals, and also in these suits there are different category of suits which are supposed for a tort case, for a contractual dispute, how the timelines are provided in the Limitation Act. For example, the suit for possession of immovable property based on title is 12 years. A suit for compensation for false imprisonment is 1 year. And also there is another clause, article which is Article 137, which says that in events wherein no time period is prescribed under limitation, then for all those applications the limitation period will be that of 3 years. Now moving on to the link between the Insolvency and Bankruptcy Code and the Limitation Act. So Insolvency and Bankruptcy Code came in to 2016. The Limitation Act came in 1963. So the question came that whether the provisions of Limitation Act will be applicable to the Insolvency and Bankruptcy Code. So accordingly, the deliberations happened and different courts were giving different interpretation as to the applicability of provisions of Limitation Act to the Insolvency and Bankruptcy Code. The Insolvency Law Committee report of March 2018 observed that given that the intent was not to package the code as a fresh opportunity for creditors and claimants who did not exercise their remedy under existing laws within the prescribed limitation period, the committee thought it fit to bring a new provision under the Insolvency and Bankruptcy Code through an amendment. So an amendment was carried out to the Insolvency and Bankruptcy Code. The amendment was Section 238A, which was brought vide Insolvency and Bankruptcy Code, Second Amendment Act 2018, and the same came into effect from June 6, 2018. For the understanding, this is the provision which was brought. It reads, the provisions of the Limitation Act shall, as far as may be, apply to proceedings or appeals before the adjudicating authority, National Company Law Appellate Tribunal, DRTs or DRATs. So friends, the question which then arose was, what is the meaning of this term as far as may be? Will all the provisions of the Limitation Act will apply to the Insolvency Bankruptcy Code, or some provisions will apply to the Insolvency and Bankruptcy Code? To settle this, the Supreme Court recently in a judgment in the case of Seshnath Singh and another versus Badhyanath Shiropalli, Cooperative Bank Limited and another, observed that the expression as far as may be is indicative of the fact that all or any of the provisions of the Limitation Act may not apply to proceedings before the adjudicating authority or the appellate authority if they are patently inconsistent with some provisions of the Insolvency and Bankruptcy Code. So suppose the provisions are not inconsistent with the provisions of the Insolvency and Bankruptcy Code, then those provisions of Limitation Act will apply. In the context of Section 14 of the Limitation Act, which provides for exclusion of time period for pursuing remedy before a court without jurisdiction, then in that context, the court also held that at the same time, the words as far as may be cannot be construed as a total exclusion of the requirements of the basic principles of Section 14 of the Limitation Act, but permits a wider, more liberal, contextual and purposive interpretation by necessary modification, which is in harmony with the principles of the said section. Therefore, the court said that yes, Section 14 of the Limitation Act will be applicable to the insolvency and bankruptcy proceedings. Then another question came, which was, what will be the effect, whether the amendment, which is Section 238A, will be having a retrospective effect? Then the Supreme Court, in another matter called the BK Educational Services Private Limited versus Parag Gupta and Associates, observed that the intention is never not to revive the claims which are already dead. And it illustrated that the code cannot be triggered in the year 2017 for a debt which was time-barred, say, in 2019, as that would lead to an absurd and extreme consequence of the code being triggered by a stale or dead claim. It also said that the right to sue accrues when a default occurs. So default occurs when someone is unable to pay its debt, and the amount of threshold for a corporate entity under the Insolvency and Bankruptcy Code is 1 crore rupees. If the default has occurred over 3 years prior to the date of filing of the application, then that would debar such application. It would get debarred under Article 137 of the Limitation Act. Accordingly, it said that Section 238A of the Insolvency and Bankruptcy Code is actually clarificatory in nature, and it being procedural in nature will have a retrospective effect. Now, I would request Mr. C. Ramachandra Rao, General Manager, to take the presentation forward. Thank you.
Hello, friends. Now, so far, Mr. Anshul has explained about the substantive portion of the Limitation Act, how the Limitation Act will have an operation in terms of the Insolvency Bankruptcy Code, and how the things are moved regarding the purpose of agitating somebody's right, which is given under the Limitation Act. Subsequent to that, we will see some of the judgments, emerging jurisprudence, giving interpretation to various provisions of the Limitation Act vis-a-vis the Insolvency and Bankruptcy Code. Going with this, one of the important landmark judgments given by the Honorable Supreme Court in Babulal Vardar G. Gurjar versus Veer Gurjar Aluminium Industries Private Limited, wherein the Honorable Supreme Court made a clear and categorical observation with reference to the intention of the code is not to give a new lease of life to the debts which have been time barred. And also it stated that the date of code coming into force is not relevant to the triggering of the limitation period for the purposes of the code. And another important identification or the giving the proper recognition to the interplay of the Limitation Act will be that the limitation for the purposes of filing an application to trigger the corporate insolvency resolution process is governed by Article 137 of the Limitation Act, that is 3 years from the date when the right to accrue, when the right to file an application or the initiate the process accrues. Thus, the most important the section here is the section 18 of the Limitation Act, which clearly provides for where before the expiration of the prescribed period for filing a suit or filing an application before the NCLT, onboard NCLT in this particular case, or a property, the acknowledgement made by the corporate debtor with reference to the liability, the fresh period of limitation shall be calculated or computed from the date when the acknowledgement was so signed. So this, friends, clearly indicate that the Limitation Act is very much applicable, and going forward, the same was asserted by Honorable Supreme Court in the case of Dena Bank versus C. Shivakumar Reddy, which clearly says that there is no bar for filing, there is no bar in filing an application under Section 7 under the, insofar as Limitation Act is concerned, as long as there is an acknowledgement of debt which squarely falls within the definition of Section 18 of the Limitation Act, the application and the further calculation of the limitation period would accrue from the date when the acknowledgement was so signed and executed. Further, if you see another important Supreme Court landmark judgment in Asset Reconstruction Company India Limited versus Bishal Jaiswal, which says that any acknowledgement of liability or debt made in the balance sheet extends the period of limitation under Section 18 of the Limitation Act. However, it depends on case to case how the acknowledgement of liability has been made in the balance sheet qua any creditor. So this clearly gives a proper direction whether the entry made for a creditor has been made unequivocal or has been made with, entries have been made with some caveats. So this would clearly establish whether an acknowledgement of liability has been made properly or not, can be clearly established to agitate somebody's right in this regard. So moving forward, With this, our topic on the analysis and the application of interplay of Limitation Act to the Insolvency and Bankruptcy Code will come to an end. We will start the another topic, analysis of withdrawal of CIRP, Corporate Insolvency Resolution Proceedings, pursuant to settlement under Section 12A of the Insolvency Bankruptcy Code 2016. See, if you see 12A, 12A has been introduced by way of an amendment, second amendment 2018, so where it says that the adjudicating authority may allow the application, may allow the withdrawal of application admitted under Section 7 or Section 9 or Section 10 with respect to the financial creditors, operational creditors, and the corporate debtor himself on an application made by the applicant with the approval of 90% voting share of the Committee of Creditors in such a manner as may be specified. This specification has been given under the regulations by the Insolvency Bankruptcy Board of India. If you see the press release given on 6th June 2018, which says that the application of the concerned provision, that is Section 12A, says that whenever a withdrawal application has to be considered or permissible, it will be with the approval of the Committee of Creditors with 90% only. But the here immediate catch here is that the withdrawal will happen only when it will happen only before the publication of invitation of expression of interest. In other words, there won't be any withdrawal that is permissible once the commercial process has been set in for the invitation of expression of interest or bid participations. Going further, the constitutionality of the Section 12A has been challenged in Swiss Ribbons Private Limited and another versus Union of India. The constitutionality of Section 12 has been upheld here, but here the important trigger events which the observations of the Honorable Supreme Court needs consideration here. Once the code gets triggered by admission on the application of the creditor's petition, the proceedings become a collective proceedings and it will be in rem and cannot be reversed without the approval of 90% of the Committee of Creditors with its voting share. So thus, in the event the Committee of Creditors is not constituted, it is for the concerned applicant to move an application before the NCLT, who would consider in exercise of the inherent powers either to allow or reject. So going further, there are certain judgments that are emanating here. If you will see the concerned provisions also, Rule 8 of the Insolvency and Bankruptcy Application to Adjudicating Authority provides for withdrawal of application, but this will provide only withdrawal of applications before admission of the matters, not thereafter. If at all the subsequent provisions, if you will see, Rule 11 of the NCLT rules provide very clearly that under the inherent powers, the Honorable Adjudicating Authority may pass any order in the interest of the equity and natural justice. But if you see the specific provisions, it has been laid down in 30A of the Insolvency Bankruptcy Board of India CIRP regulations, which provide for withdrawal under three scenarios. Three scenarios have been given here. One is where the admission has happened. In such a case, post-admission, how it has to be done. Another scenario, after admission and before invitation of expression of interest. And third scenario will be after issuance of the invitation for expression of interest. How it has to be dealt with has also been very clearly laid down. But if you see the genesis of section 12 of the code, you will notice one important development here. The genesis, it happened that in Lokhandwala Kataria Constructions Private Limited versus Nises Finance and Investment Managers, wherein it said this judgment was given by Honorable Supreme Court in July 2017, wherein it said that the Honorable NCLT failed to exercise its power under Rule 11 of the NCLT rules. Thereby, in the interest of natural justice and equity, Honorable Supreme Court, in exercise of powers under Article 122 of the Indian Constitution, has allowed the settlement, and thus this has become an important case, paving way for some deliberations to do for enabling provisions under the Insolvency Bankruptcy Code. Further, 4 months later, down the lane, in September 2017, in the matter of Uttara Foods and Feeds Private Limited versus Mona Pharmachem, it said that, all the litigants are just moving the Supreme Court all the time for deciding on these issues. At the Supreme Court, finally it said that there is a need for amending the rules pertaining to deal with these matters. As such, it said that in order to obviate these things, there is a need to amend the law. Accordingly, Section 12A has been brought into, and we have discussed about the main ingredients of the Section 12A, and the most important logic or the most important rationale behind this is that when a withdrawal has to happen, it has to happen through the process and through the participation of all the creditors, not merely a single creditor who should take a decision in these matters. So, the main process has been given, that is how it has to be filed before the admission, after admission how it has to be filed, and who has to file the necessary application, what are the timelines are given in Regulation 30A, and the few of the judgments that are require consideration here is withdrawal of an application post expression of interest has been clearly dealt in Brilliant Alloys Private Limited versus Rajgopal, where it said that it has drawn a clear distinction between the Section 12A as well as the 30A, and it said there is no bar. 30A is only a directory in nature, not mandatory in nature. Thus, if you're going by the important other judgments, whether a resolution applicant can use 12A as an exit route, Supreme Court very clearly said in Maharashtra Seamless Private Limited that there is no way he can do it. Thus, the main important things in a settlement what we have to see is whether there is the role of the whole of the creditors in the ecosystem are participating or not is most important. This will throw a sufficient light on this withdrawal aspect of the withdrawal aspect under the Insolvency Bankruptcy Code. Thank you so much.